Okay, are you ready?
Ready.
All right, here we go. Welcome, everyone. I am here with Mr. John Tatone today. John, how are you?
I'm doing wonderful.
Good. Good. We are doing really well on our end too. And we have brought John on because he has done it all. I was talking to him before we started recording, and not only does he work in the field of probate and estate planning, John is also a real estate investor and has several more years of experience under his belt than I do. So I'm going to learn a lot from him today as well. So I'm really excited to dive into the interview. But what I want to just kick off with, John, is just go ahead and introduce yourself to us, introduce your firm to us. Let us know what it is that you do and who the people are that you serve.
Sure, Blair. Thank you very much. Pleasure being here. Thank you for inviting me.
Absolutely.
My name, as Blair said, is John Tatone. I own John R. Tatone and Associates. I have several offices. One of my main offices is located in Utica. I do a lot of stuff in Macomb County probate, but I'm also in Oakland County and Wayne County as well. Um, I've been an attorney for 26 years, had my own firm for about 20 years, and I've had my own rental properties for 14 years. And I've done various sales and flips for the last 14 years, while also keeping my own rental properties that I wanted to keep.
Excellent. Yeah, let's dive into that. So first of all, let's speak to that general person who says that's fantastic that you guys are all investors over there, but I just have some questions about mom and dad's property, Uncle Bill's property. Like all of a sudden they realize that they've been named representative, executor, etc. How does this person navigate this field? So for example, what would be a situation that would cause somebody to pick up the phone, give you a call and reach out and say, "John, I need your help."
Well, the essence of probate law is anything that's in your sole name that doesn't have a joint owner or a beneficiary has to go through probate. Some people do it right away. Some people wait decades. They find out years later that the house they've been living in for 20 years didn't automatically pass to them by some magic wand. They actually have to go through the probate process and have a deed drafted, which is what I do, to transfer the property to them. I can't draft that deed until we open up a probate case. So that's the first step, is after they call me and hire me, we have to fill out the forms necessary to file a probate case. Once we file the probate case, the court will follow the will if there is one. Many times I deal with cases where there is no will. In that
Okay.
case, we have to have some family cooperation, or else we have to go to court and have the judge order who's going to be in charge of this estate. Once they're appointed by the judge to be in charge of the estate, then they are in a position where they can sell mom and dad's house or Uncle Bill's house to an investor, a family member, a friend, or if we're following a will that says, Susie gets the house, then we do a deed transferring the house from mom and dad's name to Susie. After we get through the probate, after we file the deeds and record deeds, then we can pay all the bills that mom and dad may have owed, if there are any left, and then we can close the estate. But it's a process and it can sometimes take years. Most of my cases take 6 months from beginning to end. But it all depends on the type of assets we're talking about, the complexity, and whether the
Mhm.
family's going to fight. That's why I always prefer people come and see me before, while they're healthy. Because if I do all the correct paperwork, which I've been doing for a very long time, it avoids, number one, even bothering with probate. So we don't have to deal with that. And then on top of it, um, it makes everything much smoother and less fighting. And then there's nobody spending tens of thousands of dollars on lawyers going through probate court. So I'm here to help, but it really
Mhm.
helps me when they come to me while they're healthy before the inevitable happens. But even after that, I can help them through the probate process and get that, take care of that real estate so that an investor such as yourself could come by, make them a
Mhm.
very good offer, and then they will have the ability to transfer that property.
Okay, well let's touch on what you said about the families fighting over property. So before we hopped on, I was sharing with John that I'm very proud of my parents for getting their affairs in order, etc. And so have my husband's parents. But I do have my own personal stories from other family members. Um, the one that sticks out in my mind is my grandmother when my very elderly great grandparents passed away, and I was shocked because I was a little kid and I was watching all of these grown-ups who to me just seemed so elevated to me. I was shocked by how my grandmother and her siblings were fighting over my great grandparents' estate after they passed. And I just didn't really understand why. So can we break down like what would be the reasons that would cause family members to fight? And I'm not necessarily talking about personality conflicts or these siblings have always fought. I mean, what would be the items that siblings would fight over if an estate or the affairs were not set in order before parents passed?
I have two cases that I recently handled that I think
Okay.
would touch those points exactly. The first case was two sisters. There was actually six siblings, but the two sisters were primarily arguing. One sister hired me. The other sister had lived with mom. Mom ended up being diagnosed with dementia and slowly lost her ability to remember things, to function. And the other sister was taking care of mom, which was fine. Unfortunately, about a year prior to mom's death, the sister decided, who was taking care of mom, unknown to the rest of the family, to cash in two investment accounts totaling about $90,000.
Wow.
And she proceeded to use them for herself. And then
Spend it up.
after mom died, she put the rest in her pocket. And
Okay.
unfortunately, my client, the sister, was not having that. She appreciated everything her sister did, taking care of mom, taking care of a dementia person. A person diagnosed with dementia is not easy in itself.
Mhm.
Uh, but the fact that she did things so secretly, she used the power of attorney, and she's not supposed to use a power of attorney to benefit herself, but only her mother. So she kind of abused the power. And after trial, the judge awarded my client, actually the estate, ordered the other side to refund the money that she had taken. So
Okay.
that's one of the cases where people fight because they're taking mom and dad's money while mom and dad are mentally um, impaired and taking
Mhm.
advantage. The second case I just settled last week, where a sister again was taking care of mom and had mom, actually, she typed up a will for mom and had mom sign the will, and then had it notarized, took mom to the bank, even though mom probably didn't know what was going on, had mom had that will notarized. Will was notarized, and then she passed away. And again, the sister did not mention to anybody that mom had a will, that she had done a will a year prior to mom's death, nothing. And then my client finds out after the fact, not only did she do a will, she did a deed. So she had mom sign a deed to the house, which was mom's primary asset. And of course, only give it to the sister, despite there being three siblings. And we ended up having to go to court to fight over whether the deed was valid or not, because this woman did her own deed, which I do not recommend. I've had a number of cases where people do their own deeds and they just don't do it correctly. And then it doesn't do what you think it's going to do. And you end up in probate court anyway. So
Mhm.
in that case, the second case, we ended up settling the case and we made a very fair distribution. We agreed to sell the house and then do a fair distribution of the proceeds. But again, it could have been avoided. Both of those cases
Mhm.
could have been avoided if they would have went to see an attorney ahead of time and had everything in black and white.
The question that pops into my mind when you say that is, if there is a will in place, isn't that ironclad? I say that with a wink and a smile because I understand that it's not, but I believe that there are quite a few people out there who would believe, well, my mother, my father, whomever was in a lucid state of mind, they knew exactly what they were doing when they put this will together. But obviously, we see that afterward, it didn't have that sticking power. It wasn't ironclad. Why not? How come a written, drafted, notarized will
So
doesn't have the power?
there's some rules. There's actually some very
Mhm.
specific laws that say a will is supposed to be witnessed by two people. So having one notary is nice, but it's one person. You need two people for a statutory will. And again, it helps when you have disinterested people with that statutory will as witnesses so that they can come in and testify. We talked to this person. We asked her questions. She knew what she was doing. She understood what she was signing. That's the purpose of having those witnesses there. And when they're disinterested, they're not family. It really helps because they have nothing to gain and nothing to lose by telling the truth.
Mhm.
So a will is a great thing, but if it's not done correctly, it throws red flags to everybody else, especially the lack of transparency.
Mhm.
When I do estate planning for clients, I recommend that they let the family know. They don't have to share the documents unless they want to, but they should let the family know that they've done these estate planning documents so that there isn't a surprise later on down the line.
So, couldn't an individual, just like an individual, could write their own will if they follow the different stipulations that you just mentioned? So, what about the concept of DIY is really popular. We go on Pinterest and we want to just DIY everything. Can't we just DIY our own estate plan? How does that work?
You can. There's services out there, there's software out there where people do their own. The problem is, again, sometimes they have witnesses, sometimes they don't. Sometimes they're vague because these pre-printed forms that you're going to use may use terminology that doesn't exactly apply to Michigan law. So they're
Hmm.
nationwide and they don't specifically state exactly what the decedent intended. And there might be different ways of interpreting the language in that will. And of course, one side is going to interpret it one way, and the other side is going to interpret it a different way. And then you're going to go to court, and the judge is going to have to listen to testimony, look at evidence, and determine what the decedent meant by this language in a DIY will. When you have
Hmm.
an attorney do it, generally it's very, very specific. They know how to use the legalese and the legal jargon that needs to be in there. And that will help anybody interpret exactly what the decedent wanted when they pass away.
So it's more tailored to the individual than just this general document. And you bring up a good point. There there are times when it is tempting to just pull something off of the internet, but again, as we were talking before we hit record, that I use an attorney that is specific to real estate law for any of the ventures that I want to go out on. There's usually always documents, contracts, etc., agreements that you have to structure and put into place, and I have no idea. I have a background in elementary education. I have no idea how to write the contract. So I don't know how to draft it. And then I also don't really know how to interpret it. Obviously, I can read it, but if there are sections that I don't really understand, I feel like that's a huge red flag that I just don't know how to interpret these documents myself. So in a situation like this where something is really important, this isn't really an arena that I feel like people should be playing around in unless it's their expertise. So when people come to you, typically at what phase are they in? Should it only be an older person that has accumulated wealth and has many children At what point in time should someone come to an attorney and say, I really need to get my affairs together?
There is no such thing as too early. Unfortunately,
Okay.
after doing this for 26 years, I've had parents come to me that had to go through probate because their 30-something-year-old child passed away from a car
Mm,
accident. I had a case just last year um,
mm.
where a girlfriend came to me who was living with her soon-to-be husband. They were engaged, and he had a motorcycle accident and died.
That's so
And
sad.
because the house was half in his name and the deed was not done correctly, and half in her mother's name, half of the house had to go through probate.
Wow.
And even though my client, the girlfriend, fiance, was paying the house payment, paid a chunk of the down payment, she didn't put her name on the deed because she had bad credit. So
Mhm.
the mortgage company kind of helped with the deed and only put his name on it. Well, he had a child from a prior relationship. So that child is his heir.
Mhm.
That the fiance actually has no legal rights at all.
Wow.
But we worked it out. I was able to get it done. But he died and he was in his 30s, motorcycle accident. So had he done a will, um, it wouldn't have been a big deal and it wouldn't have been as big of an issue because it would have specifically said where that half a house goes. But if he would have came to me when they purchased the house, the deed could have been fixed and it could have been done right. And then it would have automatically passed outside of probate to his fiance without even going through probate court.
How do you probate half of a house? Does that look like, you just take the value of it, you split it down the middle? Is there a sale that has to go forward? Like, how do you do that?
We ended up settling, so we didn't have to do that. But yes, technically, the judge could order a sale of the house. The
Mhm.
heir that's supposed to inherit the one half of the house can file a lawsuit against the other person and say, I don't want to be partners with this person on this house. So, what would normally happen is that half a house would be transferred to the heir. And then the heir would then be partners with whoever the other person is. And if they don't want to be partners, they have to file another lawsuit in court called a partition action, where the court will order the property sold and the proceeds divided according to equity or whatever the judge thinks is fair.
Or if that individual who wanted to keep the house had the cash to buy out the other half, would that
And
be an
that
option?
and that's kind of what we did in our settlement, where the
Okay.
fiance wanting to keep the house took some of the assets that she had and took care of the heir of her deceased fiance, so
Mhm.
that he really didn't want half the house. He'd rather have cash.
Sure, and that's just not typically, that's just not an option for a lot of people. They'd find themselves in a situation where you just have to sell the assets so that
Right.
you can, satisfy that other end. Wow, that is a sad story. So I'm thinking about my own self, my own situation. Um, so I am a stay-at-home mom, but my husband is a high school teacher, and we own a handful of rental properties, and we flip a handful of homes a year. So how could someone like myself, I'm not necessarily the person who's thinking about my own personal home, but I'm thinking about the investment assets that I own. And so, as we said at the beginning, you're also a real estate investor. So I feel like the best advice is going to come from you. It's like you're not only someone who just like talks the talk, you walk the walk, and you've been walking it out for over a decade as well. How can someone protect their investment assets in terms of real estate investments?
Well, my best example is my own example. So I have
Okay.
rental properties. My wife and I have a trust. We have three children. And what we did is we have all of our assets either in the trust or going to the trust upon our death by beneficiary forms. As far as the rental properties go, I have created limited liability companies for the rental properties, and that's a whole nother story for you. Maybe I'll tell you later. But the LLC is owned by the trust. So automatically, the LLC goes to the trust. The trustee, whoever is in charge, and it doesn't have to be one of my kids, it can be an adult, friend, or family member, will have the ability, and I can put the detail in my trust to either keep the property and give each one of my kids some of the property, or I can put right in the trust there to liquidate or sell the property and then put the cash into each kid's account for the trust. And then everybody's protected, everybody's taken care of, and there is no probate because the LLCs are owned by the trust.
Okay, let's dive a little deeper into that protection. What exactly does the trust protect them from? I know that you just mentioned that there would be no probate, but what exactly is probate, and why would it be something that we would want to protect ourselves from in the first place? So let's just unpack
Sure.
that whole right there.
So by having a trust, it's basically an instruction book for what happens to your assets. And a trust by law is considered a separate entity from the individuals. So it kind of insulates you from any liability. So if there is a problem, just like the LLCs do. So if there's a problem at one of the rental properties, there's a slip and fall. For some unknown reason, I don't have enough insurance to cover it, which I always recommend insurance on a rental property. But if you don't, they can't come after my personal house because my personal house isn't owned by the LLC. They can only take the assets that are in that LLC. But it's something similar with the trust. You can't get what's in the trust if you sue me individually because I don't own that property. I don't own the LLC. The trust owns the LLC. So there's
Okay.
a liability aspect to it, but there's also that automatic passing because a trust never dies. So the death of me and my wife would just be a triggering event in the instruction book, which is the trust, that says what to do with the LLCs that the trust owns.
Okay. So when a person passes, and this is me asking for clarification, when a person passes and they don't have anything in any sort of trust or entity or anything like that, their death then triggers the probate process, because is that just the next step in the process if there is no instruction manual, like how you referred to that?
Yes. And I have a
Oh,
pending case to tell you a story about.
great.
So this family came to me about a month ago. Dad had two properties. One he lived in, one was a rental. And he decided to do his own deeds. He put all of his kids on the deeds with him. So he did a quick claim deed to himself and all the kids. He forgot to include some special language that would have made it automatically transfer to the six
Mm.
kids. So because he didn't have that language, they have to go to probate court over 1/7 of the house. And that's
Wow.
each house. To make things even more complicated, one of the children on the deed predeceased dad,
Mm.
and dad didn't remove them, couldn't remove them from the deed. So now we have to deal with that deceased child's two children, and we have
Mhm.
to require them to open up a probate estate so they can receive 1/7, their mom's 1/7 of that house as well. So it gets really, really complicated when people don't do, and this is just two houses. It
Mhm.
gets really complicated when people don't do the right thing, and it's going to cost this family thousands of dollars to go through probate court. It's going to take months before we're going to be able to clear the deed to a point where it's able to be sold. But actually, a real estate agent referred them to me, and she's trying to sell one of the houses, which we ended up getting the deed done and getting everybody to cooperate. So we did end up selling the first house. But dad's 1/7 of the check goes into the estate, and that gets divided between all the surviving heirs because there is no will.
Mhm. Okay.
So by doing a trust or doing other estate, we've done things like ladybird deeds, and those documents, those tools avoid probate, allow you to keep control of your property, but then of you know avoid all this unnecessary expense later on and grief later on.
Well, what is the purpose of probate anyway? Why is it a process that we have set in place? What is I understand that I understand that part of it is to answer questions or to decide who gets what, but what are all of the other factors, or who might be the other hands in the pot, outside of just family members or spouses, etc.
So I've actually had, I especially enjoy working with blended families. When people have children from prior relationships or prior marriages, it gets
Hmm.
really, really complicated. And by having wills done or trust done, it will detail where things should go. And if you don't have a will or a trust, there are statutes, there are laws in Michigan that say if you don't have a will, this is who gets your stuff, whether you want them to or not, whether you've talked to them in the last 20 years or not, whether they were
Hmm.
nice to you or not. You could hate this person and they could end up with your stuff because you don't have your stuff, your estate planning done. And that's the purpose of probate, to make sure that property and assets go to the right people. So
Hmm.
the law gives you an opportunity to do a will or do a trust. But if you don't take that opportunity, the law dictates where it's going to go.
Okay, so we have the freedom and the option to structure things the way we want to. We can either set up our own choices ahead of the game, or the state is just going to make those choices for you in the end. So that seems like that's the
Exactly.
purpose of.
So one of
So
my
either
favorite
choose
stories,
now, or someone will choose for you later.
I'm sorry, one of my favorite stories is my grandfather, just like you had your
Mhm.
grandparents' story. My grandfather got divorced way back in the day when it was very uncool to be divorced. He remarried, sweetest lady in the world. We all really adored this woman. At that point, all of his kids are grown. All of her kids are grown. She has kids from a prior. He has kids from a prior. Everybody thought that my step grandmother was going to pass away first. She was diabetic. She had a couple of missing fingers, actually. Um, and she was never very, very healthy. My grandfather ends up passing away first, even though he was the healthiest 75-year-old I'd ever met. He was still renovating houses. He had rental properties as well. And he was renovating houses at 75 years old. He has a heart attack. He passes away. By law, everything went to his wife, to the exclusion of my mother and her three brothers. Then she ends up suffering from dementia, moving in with her children. Then she passed away. So anything my grandfather had went to her and then to her children. And my mom and her uncles never saw a penny.
Wow.
No will, no
Mhm.
direction, and the law will tell you where it's going to go.
Mhm. Yeah, I think there's a lot of wisdom to be taken away from the conversation today of just forward thinking, regardless of what age you are, and then also just the different paths that we find ourselves going down can just go in so many different directions, and it's a difficult conversation maybe to have about your future passing, which is inevitable. It'll happen to all of us. But I think there's a lot of wisdom to be pulled from this conversation of just sitting down and having those hard conversations, maybe even with some people that you don't communicate with on that level anymore, and just setting aside your emotions and getting all that out there. Because I know that one of the common themes when we think about estate planning is the assets or the money that could be involved. But I'm thinking also about just the different pain that people go through, the emotional pain or the stress. Have you ever had a reluctant executor or personal representative? Have you ever had someone who, when someone passes that, like, the probate torch, the mantle was passed to this person, and the person just did not want to take on that responsibility, or it was a very stressful thing for them. So I'm thinking about that, like just the different stress that a person might go through. The people who are left behind, they have to navigate through all of this, and it could be a very lengthy process as well.
And that's the worst part, that here you
Mhm.
just lost a loved one. You end up having to go to court, sometimes fighting in court for months or years, and you never really get to that point where you fully grieve the loss that you just suffered. So
Mhm.
it's almost like putting kerosene on a fire. Uh, it just it just makes things that much worse because mom or dad or a family member didn't pre-plan, didn't think ahead and say, you know what, I'm gonna set this up so that people don't have to worry, people don't have to
Mhm.
be concerned, and people don't have to fight because it's a very, very emotional time. Can I
Mhm.
tell one more story about that?
Absolutely, please.
So, my father in law unfortunately passed away a little over 2 years ago. And I met my mother in law at the funeral home. And she beat me there by 5 minutes. And she was thumbing through a catalog of caskets. And she said, when I got there, I really like this one for $5,000. And I said, Mom, and I introduced myself to the funeral director that's sitting across the table from us at the time.
Mhm.
I said, Mom, I thought, Dad wanted to be cremated. And she said, Well, yeah. And I said, Well, are you having him laid out first? And that's why you're going to get the casket? He's going to be laid out at the funeral? She said, Well, no, he's going to be cremated right away. I said, Well, he can be in a pine box then. It really doesn't matter. It's all going to be burned and nobody's going to see it. And she turned to me and she's like, Yeah, you're right. I didn't think of that. It's the emotion. She was just so upset about the loss that she wasn't thinking clearly. And obviously, the funeral director, and there's been some great ones that I've had the pleasure of meeting, but there's also some bad apples in the bunch, are going to,
Sure.
and others who may take advantage of somebody who's, just suffered that loss and everything isn't lined up. One of the
Mhm.
documents I do as part of my estate planning packages is a funeral directive. And you actually list whether you want to be buried, whether you want to be cremated, whether you want organs donated, whether you want a funeral, whether you want an open casket, closed casket, just the celebration of life. So we
Mhm.
can get as detailed as you want, and it's one less thing that your loved ones have to think about as they're going through this process of grieving the loss. And it just makes it easier on them, and it helps keep them from being taken advantage of.
That just really blows my mind to picture her sitting there emotionally compromised, and there's someone across the table from her trying to upsell her a casket that's going to just be cremated anyway.
Yeah, I could feel the
Wow.
tension. When I said, "You don't have to buy the casket," I could feel that director just tense up. He just lost a $5,000 sale.
Here he thought he was gonna make the sale. That's things that we don't think about, you think about furniture salesmen, car salesmen, we don't those
Well, and
pesky
the average funeral is costing $12,000 nowadays. So some
Mhm.
of my clients are just opting for a celebration of life at their favorite restaurant, spend a couple $1,000s, tell
Yep.
some great stories about me, share some pictures, and call it a day. And
Mhm.
I understand where they're coming from. That's a lot of money.
Oh, absolutely. Well, for those of you who are watching this video, I am sure you realize what a treat it was to have John on the show today and just share all of this. And so, if anybody has received any value, then I'm just going to ask you to go ahead and scroll down into the description section below. And we're going to post, John's going to give his contact information here in a moment, but we're also going to make sure that that's posted down in the description section below. And if anyone has connected with any of these stories and you would like to share, just go ahead and leave us a comment about any similarity that you have. And if you have any questions, don't post those in the comment section. I can't answer your questions, but reach out to John, give him a call with all of your questions, because I know that he can very competently answer them. And I also feel like, just on a personal note, it is great to have the intelligence quotient, but I really feel like there's an emotional quotient here with you as well, John. That it's not just going to be a business conversation. It feels like you really connect with your clients, and this difficult process, you really help them to navigate through not just the paperwork, but the emotions of it all as well.
That's the goal. I'm just here to help. And if I can help some families avoid a lot of grief and a lot of heartache, then I've done my job.
Oh, that's fantastic. So yes, please do all of that YouTube stuff. Like and subscribe, because when you do, it helps to get this information into the hands of those who needed it just as badly as you did. So for those who are viewing at home, though, and they're thinking to themselves, I really need to give John a call. How can folks reach out to you, John? Where can they find you?
Sure, they can always call the office at 586-580-8850, or they can send me an email, jt@johntatone.com.
Okay, and then I can't remember if we said it on the recording or off the recording. Where is your office located?
So I have several satellite offices
Okay.
in Oakland County, Wayne County, and Macomb County. My
Mhm.
Macomb County office is located near Hall Road in Van Dyke in Utica.
Okay. All right. Well, thank you so much. We're going to get that information also posted in the description field below. But John, thank you so much for the interview today. It was a pleasure to talk to you, and we all really appreciate your time and your expertise and your stories.
Thank you very much, Blair. It's been wonderful. I really appreciate you having me on. All
Absolutely. Take care.
right, bye-bye.
All right. Don't click off. I'm just going to click stop recording here.
Don't press the button.